International human rights law is the body of international law intended to promote and protect human rights at the international and domestic levels. Human rights are the basic entitlements that belong to each and every one of us, regardless of our background, where we live, what we look like, what we think, or what we believe, based on the principles of dignity, equality, and mutual respect. They have been agreed upon by governments from all around the world. As a form of international law, international human rights law is primarily made up of treaty law and customary international law. Rules of law derived from the consistent practice of states, while international treaty and customary law from the mainstay of the international human rights law. Other instruments, such as declarations and principles adopted at the international level, contribute to its understanding, implementation, and development. The Universal Declaration of Human Rights, adopted by the United Nations on December 10 of 1984, sets out the basic rights and freedoms that apply to all men, women, and children. It has become the most important document of its kind, and although not legally binding itself, forms the basis of many legally binding international agreements. International human rights law protects people from racial discrimination, from torture, and from forced disappearance. They also recognize the rights of specific groups of people, including women, children, people with disability, indigenous peoples, and migrant workers.
Enforcement. Enforcement of international human rights law can occur at either a domestic or an international level. States that ratify human rights treaties commit to respecting, protecting, and fulfilling those rights, and ensuring that their domestic law is compatible with international standards. When domestic law fails to provide a remedy for human rights abuse, injured parties may be able to resort to international mechanisms for remedy. International human rights law and international humanitarian law. International human rights law is closely related to, but distinct from international humanitarian law. They are complementary since the substantive norms they contain are often similar or related. However, international human rights law applies all the time, including during situations of emergency and conflict. International humanitarian law is a legal regime that only applies to armed conflicts, including occupation, when both legal regimes apply in tandem. Modern development of human rights. Modern international human rights law has developed since the drafting of the United Nations Universal Declaration of Human Rights in December 1948. Drafted as a common standard of achievement for all peoples and nations, the Declaration spells out civil, political, economic, social, and cultural rights that all human beings are entitled to. It has been widely accepted as providing the fundamental norms of human rights that everyone should respect and protect. Since 1945, a series of international human rights treaties and other instruments have been adopted, conferring legal form on inherent human rights and further developing the body of international human rights.
State obligation and procedure. International human rights law prescribes obligations which states are bound to respect. strong ratification of the international human rights treaty. Governments undertake to put into place domestic measures and legislation compatible with their treaty obligation. By becoming parties to international treaties, the state assumes obligations and duties under international law to respect, protect, and fulfill human rights. The obligation to respect means that the state must refrain from interfering with or curtail the enjoyment of human rights. The obligation to protect requires states to protect individuals and groups against human rights abuse. The obligation to fulfill means that the state must take positive action to facilitate the enjoyment of basic human rights. Human Rights Council. The Human Rights Council is composed of 47 elected United Nations member states empowered to prevent abuse, inequity, and discrimination, protect the most vulnerable, and expose the perpetrators of human rights violations. The Council establishes space, procedures, or mechanisms to address either specific country situation or thematic issues across the globe. Special producers are either an individual, a special rapporteur, or representative, or independent expert, or a working group. They are prominent independent experts working on a voluntary basis and are appointed by the Human Rights Council. There are currently 30 thematic mandates and 8 country mandates are reported to the Human Rights Council on their findings and recommendations.
Human rights treaty bodies. There are currently 10 human rights treaty bodies, committees of independent experts, created in accordance with the provision of the treaty that they monitor. 9 of these treaty bodies monitor implementation of the core international human rights treaties, while the 10th treaty body, the Subcommittee on Prevention of Torture, established under the Optional Protocol to the Convention Against Torture, monitor place of detention in state parties to the Optional Protocol. Additionally, there are several other United States bodies which are concerned with the promotion and protection of human rights. Regional monitoring and enforcement mechanisms. Beyond the UN system, there are regional systems of international human rights law that complement the national and international human rights law, by protecting and promoting human rights in specific areas of the world. There are 3 key regional human rights instruments: the African Charter on Human and People Rights, the American Convention on Human Rights, and the European Convention on Human Rights. The relationship between international human rights law and international humanitarian law is disputed among international law scholars. This discussion forms part of a larger discussion on fragmentation of international law. While pluralist scholars conceive international human rights law as being distinct from international humanitarian law, proponents of the constitutionalist approach regard the latter as a subset of the former. In a nutshell, those who favor separate, self-contained regime emphasizes the difference in applicability. International humanitarian law applies only during armed conflict. On the other hand, a more systemic perspective explains that international humanitarian law represents a function of international human rights law. It includes general norms that apply to everyone at all times, as well as specialist norms which apply to certain situations, such as armed conflict between both state and military occupation, or those certain groups of people, including refugees, children, and prisoners of war.